On August 10, 2020, a Kano State Sharia court issued a death sentence on a 22-year-old man named Yahaya Sharif Aminu. His crime was a song. He had composed a song that a Kano Sharia court determined contained blasphemous content about the Prophet Muhammad. He shared it on WhatsApp. Someone in the group reported it. He was arrested, tried without adequate legal representation, and sentenced to death. While he sat in detention, without access to his family, without a lawyer, in a cell in a country's constitution that guarantees him the right to freedom of expression, freedom of religion, and the right to a fair trial, the federal government, the constitutionally mandated government to protect every Nigerian citizen fundamental rights, regardless of which state they live in, said nothing, filed nothing, did nothing. Now, I want you to understand something before we go further. This is not an isolated case. It is not an aberration. It is not the product of one rogue judge in one compromised court making one extreme decision that the system later corrected and learned from. It is the system, working exactly as designed. In the same year, 2020, a 16-year-old boy named Omar Farouk was sentenced to 10 years in Kano State for using foul language towards Allah in an argument with a friend. Not a sermon, not a public declaration of apostasy. An argument, the kind of argument that teenagers make every day in every country on earth. 10 years in a cell for words. Both sentences were eventually interrupted, not because the federal government acted, not because the Supreme Court ruled, not because the Constitution was enforced, but because external pressure, civil society intervention, and the specific procedural errors of the courts provided escape valves that released the immediate pressure without touching the legal architecture that produced the sentences. Yahaya Sharif Aminu is still in legal jeopardy as of the most recent available reporting. The case was remitted for retrial. The architecture that produced his death sentence is still standing. The judge who issued it is still on the bench. The law under which he was sentenced is still in force, and the WhatsApp group that reported him, the community that decided a young man's song was worth his life, is still there. Here is the question that this investigation is going to answer. How does a country with a written constitution, a federal Supreme Court, a National Assembly, and 60 years of post-independence jurisprudence arrive at a place where a 22-year-old can be sentenced to death for a WhatsApp message in 2020, and the response from every federal institution with constitutional authority to intervene is silence? The answer to that question is not about one case. It is about a system. And the system has been 25 years in the building. If you are new here, subscribe before we go further. This channel exists to deliver the analysis mainstream Nigerian media won't touch. It gets deeper from here. To understand how Yahaya Sharif Aminu ended up on death row for a WhatsApp message, you have to understand the legal architecture that made that sentence not just possible, but within the framework of the courts that issued it, correct. The blasphemy provisions operating in Kano and several other Sharia states derive from classical Islamic jurisprudential positions on the crime of Sab al-Nabi, insult to the Prophet. Within classical Islamic jurisprudence, this is one of the most contested areas of Sharia law. Different schools of jurisprudence hold different positions on whether blasphemy is a hard offense, a fixed punishment offense, or a discretionary one. The Maliki school, which is the dominant jurisprudential tradition in northern Nigeria, has historically taken the position that Sab al-Nabi is a capital offense. But even within the Maliki tradition, there are significant scholarly debates about what constitutes the offense, what evidentiary standards apply, and what procedural requirements must be met before a capital sentence can be issued. What the Kano Sharia Court did in 2020 was apply the Maliki capital punishment position without the full evidentiary and procedural framework that classical Maliki jurisprudence requires to accompany it. The Kano High Court's decision to remit the case for retrial was based precisely on this procedural failure. The Sharia Court had not followed its own rules. Not because a death sentence for blasphemy is unconstitutional under Nigerian law, that question was never addressed, but because the court had skipped procedural steps. This is the pattern that this investigation has documented across every major Sharia criminal case since 1999. The escape valve is always procedural, the constitutional question is always avoided, the legal architecture is always preserved. Now look at what that architecture actually contains, because most Nigerians, including most educated southern Nigerians, do not know the specific content of the laws operating in the 12 Sharia states. The Zamfara State Sharia Penal Code, the template that most other Sharia states followed, criminalizes the following among other offenses with the following punishments: adultery, death by stoning for a married person, 100 lashes for an unmarried person. Fornication, 100 lashes. Theft above a specified value threshold, amputation of the right hand for a first offense, amputation of the left foot for a second offense. Robbery with violence, crucifixion or amputation of alternate limbs. Apostasy, leaving Islam, death. Blasphemy, insulting the Prophet or Islam, death. Consumption of alcohol, 80 lashes. These are not theoretical provisions, they are operational law in 12 Nigerian states. They have been used to issue sentences, some carried out, some interrupted by external pressure, some waiting in the legal system for resolution. Now read Section 34 of the 1999 Nigerian Constitution. Every individual is entitled to respect for the dignity of his person, and accordingly, no person shall be subject to torture or to inhumane or degrading treatment. Read Section 33. Every person has a right to life, and no one shall be deprived intentionally of his life, save in execution of a sentence of a court in respect of a criminal offense of which he has been found guilty in Nigeria. Read Section 36. Every person who is charged with a criminal offense shall be entitled to a fair hearing in public within a reasonable time by a court or tribunal. Read Section 38. Every person shall be entitled to freedom of thought, conscience, and religion. Read Section 39. Every person shall be entitled to freedom of expression, including freedom to hold opinions and to receive and impart ideas and information without interference. A 22-year-old sentenced to death for sharing a song on WhatsApp, a 16-year-old sentenced to 10 years in prison for an argument, both in 2020, both in Kano, both in a country where those 5 constitutional provisions are supposed to be the supreme law of the land. The Supreme Court has never ruled on the conflict between those constitutional provisions and the Sharia penal codes of the 12 states. Not once in 25 years. Let us go through every major Sharia court case that exposes the system. Documented, named, precise, because the pattern across these cases is the evidence. Yahya Sharif Aminu, Kano State, 2020. 22 years old, composer of Islamic devotional music, shared a song on a WhatsApp group. The song was reported to authorities as blasphemous. He was arrested. He was tried. He was not provided adequate legal representation at trial. He was not given sufficient time to prepare a defense. The trial moved with a speed that excluded any meaningful legal challenge to the proceedings. He was sentenced to death. He was held in Kano's central prison. His family was not given regular access to him. His legal situation was not publicly known for months. His family's house was burned by a mob before his trial concluded. The case reached the Kano High Court on appeal. The court remitted it for retrial at the Sharia court on the ground that the Sharia court had not administered the required formal warning to the defendant before passing sentence, a procedural error, not a constitutional ruling, not a finding that a death sentence for a WhatsApp message violates any Nigerian law. The retrial was ordered. The architecture was preserved. Yahaya Sharif Aminu remained in legal jeopardy. The federal government filed no brief. The Attorney General of the Federation issued no statement on the constitutional validity of the proceedings. The National Assembly held no hearing. The Supreme Court received no case. 22-year-old, death sentence, WhatsApp message, federal silence. Omar Farouk, Kano State, 2020. 16 years old, had an argument with a friend, used language deemed offensive towards Allah, was reported, was arrested. He was held for 5 months before his case received any significant attention. 5 months, a minor child in a cell, without consistent family access, without legal representation provided by the state. He was sentenced to 10 years in prison. The sentence was eventually overturned by the Appellate Division of the Kano State High Court, but the overturning required sustained external pressure, documentation by human rights organizations, attention from international media, legal intervention by organizations outside the state. Without that external pressure, a child serves 10 years for words spoken in an argument. The question this case raises is not just about Omar Farouk. It is about the hundreds of cases that never generated external pressure. The defendants who had no access to human rights organizations, no international attention, no civil society lawyers willing to take their case. Those defendants, their names largely unknown, their cases undocumented in the sources available outside the state, serve their sentences quietly, in cells, in states where the federal government has chosen silence for 25 years. Mubarak Bala, Kano State, 2020 to 2022. A humanist activist and president of the Humanist Association of Nigeria, arrested in April 2020 for social media posts deemed blasphemous and insulting to Islam. He was held without charge, without trial, and without bail for approximately 2 years. 2 years in detention, without a conviction, without a formal trial. The Kano state government used a combination of Sharia law provisions and public order legislation to hold him while his case moves through procedural limbo. In 2022, he was brought before a Kano court and pleaded guilty to charges relating to his social media posts, a plea that his supporters argued was made under duress after 2 years of detention. He was sentenced to 24 years in prison. The sentence was later reduced on appeal. His case represents the use of Sharia blasphemy provisions not just in formal criminal proceedings, but as a tool of prolonged detention without trial, a function that converts the Sharia legal framework into an instrument of indefinite incarceration for anyone whose speech offends the religious sensibilities of those with access to the enforcement machinery. The Aminu Mohammed case, Kano State, 2022. A student at Shahuchi Islamia School in Kano, expelled and reported to authorities after being accused of making a statement deemed insulting to the Prophet. A mob gathered outside the school. He was attacked by fellow students. The violence was severe enough to require hospitalization. The police arrested him, not the students who attacked him, him. He was subsequently charged under Kano State's Sharia Penal Code for the alleged statement. A student, attacked by a mob, hospitalized, then arrested and charged. This case illustrates the full operation of the system. Not just the formal court proceedings, but the ecosystem of mob enforcement, community reporting, and state prosecution. The Sharia court is not just a formal legal institution. It is the apex of an informal enforcement ecosystem in which any community member can report any perceived religious offense, a mob can carry out immediate extrajudicial punishment, and the formal legal system then prosecutes the victim of the mob violence rather than its perpetrators. The apostasy cases, the invisible prosecutions. The apostasy provisions of the Sharia penal codes, death for leaving Islam, are the least documented because they are the most institutionally managed. No Nigerian has ever been publicly sentenced to death for apostasy in the formal court record, in the way that the adultery and blasphemy cases have generated public attention. But documented cases of individuals who faced community and family pressure, informal religious authority enforcement, and in some cases police detention after expressing doubt about or explicitly leaving Islam, these cases exist in the records of organizations like IHEU, Humanist International, and the Humanist Association of Nigeria. The apostasy provisions do not primarily operate through formal prosecution. They operate through community enforcement, through family structures, through social ostracism, through the informal religious authority of local imams and community leaders, backed by the knowledge that the formal legal system will support rather than protect the person facing that enforcement. The provision does not need to be formally invoked to be operationally effective. Its existence in the law code is sufficient to empower informal enforcement. Now, examine the institutional architecture that makes these cases possible, the machinery behind the sentences. Every Sharia court judge in the 12 states is appointed by the state governor through the State Judicial Service Commission, which itself is structured differently from the National Judicial Council that governs federal and state high court appointments. The independence of the judiciary, the principle that judges must be protected from executive pressure in their decision-making, is structurally weaker in the Sharia court system than in the formal federal court system. A judge who issues sentences that the governor or the community finds insufficiently severe faces informal pressure. A judge who issues sentences that attract international criticism faces the same procedural escape valve mechanism. The case is sent back on technical grounds, but the legal architecture that produced the sentence is never challenged by the executive that appointed him. The Hisbah enforcement ecosystem that surrounds the courts operates with even less formal accountability. In Kano, where the Hisbah is state-funded, state-backed, and thousand-strong, the officers who patrol streets, monitor social media, receive community reports of religious offenses, and bring individuals to the attention of the formal legal system are not subject to the procedural constraints that formal law enforcement is theoretically subject to. Documentation of Hisbah overreach, extrajudicial punishment, arbitrary detention, enforcement of conduct standards against non-Muslim residents exists in human rights reports but has never been the subject of any formal government investigation in any Sharia state. The community reporting infrastructure, the informal network of mosques, Islamic community organizations, and individual informants that whose reports initiate the formal prosecution process, is the least visible but most operationally significant element of the system. Yahaya Sharif Aminu did not come to the attention of Kano authorities through police surveillance. He came to the attention because someone in his WhatsApp group reported him. That person, whoever they were, initiated a process that ended in a death sentence. They faced no accountability for that initiation. They faced no scrutiny of their motives. They were not required to demonstrate that their report was made in good faith, rather than out of personal animosity, community politics, or the desire to weaponize the religious enforcement system against an individual target. A legal system in which any community member can anonymously initiate a capital prosecution against any other community member by reporting a WhatsApp message is not a justice system. It is a persecution system with a legal veneer. Now address the counter-arguments. The strongest argument made by defenders of the Sharia court system is the rule of law argument. These courts were established through state legislation, operate under codified legal provisions, follow documented procedures, and are subject to an appeals process. They are not extrajudicial lynch mobs, they are formal legal institutions operating within a legal framework that the populations of their states voted for governments to establish. The rule of law in a federal democracy includes the laws of states, not just the laws of the federal government. This argument has institutional merit and must be engaged seriously. The response is constitutional and precise. The rule of law in Nigeria is not simply whatever laws state governments enact. The rule of law is the constitutional framework within which all laws, federal and state, must operate. Section 1, subsection 3 of the 1999 Constitution states explicitly that if any other law is inconsistent with the provisions of the Constitution, that law shall, to the extent of the inconsistency, be void. A law that sentences a person to death for sharing a WhatsApp message is explicitly protected by Section 39's Freedom of Expression Guarantee, is inconsistent with the Constitution on its face. It does not matter that the law was enacted by a democratically elected state legislature. It does not matter that it is codified provision of a formal legal code. It does not matter that it follows documented procedures. A law that produces constitutional violations is void to the extent of those violations. That is not an opinion. It is Section 1, subsection 3 of the Nigerian Constitution.
The problem is not that the argument is not available. The problem is that no Nigerian institution with the authority to make it formally has been willing to make it. The constitutional argument is sitting in plain sight in the text of the document that is supposed to govern this country. It has simply never been used. The three biggest misconceptions. The first, these cases are exceptional. They represent extreme applications of Sharia law that the mainstream of the system does not reflect. The documented cases I have presented are the cases that attracted external attention and generated documentary records. They are not the full universe of Sharia prosecutions in the 12 states. They are the visible fraction of a larger system that operates mostly without documentation, without international attention, and without the civil society intervention that provided escape valves in the high-profile cases. The exceptional cases are not exceptional because the sentences were extreme. They were exceptional because someone was watching. The second, the courts corrected themselves. The cases were overturned. The system works. The cases were not corrected by the system. They were corrected by external pressure on procedural grounds that left the system intact. The constitutional questions were never addressed. The legal architecture was never challenged. The next case will proceed through the same framework. The same evidentiary standards will apply. The same absence of federal constitutional challenge will persist. The system did not correct itself. It managed the pressure. Those are different things. The third, these only affect Muslims. Non-Muslims are exempt from Sharia jurisdiction. The formal legal position is that Sharia courts have jurisdiction only over Muslims. The operational reality is different. Hisbah enforcement in commercial and public spaces affects non-Muslims who share those spaces with Muslims. The community reporting infrastructure does not always check the religious identity of its targets before initiating a process that the formal legal system then has to manage. And the broader governance environment created by a state that operates a parallel legal system with capital punishment for speech and belief affects every person who lives, works, or travels in that state, regardless of their religion. Drop a comment right now, before the strategic outlook. If you were the Attorney General of the Federation, what specific legal action would you take tomorrow morning on the Yahaya Sharif Aminu case? Tell me below.
The reform dimension of this story has a specific and underreported institutional history. The cases that were overturned because of WAPA, because of Baobab, because of the Humanist Association of Nigeria, because of Amnesty International's Nigeria desk, because of individual lawyers, many of them northern Nigerian Muslims, who took cases without pay against institutional resistance with no government support and won on procedural grounds because winning on constitutional grounds was not available to them in a system that the federal government had chosen not to challenge. These organizations operated and continue to operate in a legal environment that systematically disadvantages them. They receive no federal funding. They receive no state cooperation. They operate in states whose governments have every institutional incentive to obstruct them. And they have, case by case, provided the external pressure that the procedural escape valve mechanism requires to function, because without that pressure, Safia Hussaini is stoned to death in 2001. Amina Lawal is stoned to death in 2003. Yahaya Sharif Aminu is executed in 2020. The institutional reform that this system requires is not complex. It requires a federal attorney general willing to file a constitutional challenge to the blasphemy and apostasy provisions of the Sharia penal codes on Section 39 freedom of expression grounds. It requires a Supreme Court willing to hear that challenge without procedural avoidance. It requires a federal government willing to enforce the outcome. None of those three conditions currently exists. The question is, what creates them? The answer, historically, is visibility. Every case that generated international attention created the procedural escape valve that saved a life. Visibility is not sufficient for structural reform, but it is the precondition for the political pressure that makes structural reform possible. That is why this investigation exists, not to relitigate cases that have already been resolved, but to make visible the architecture that keeps producing them, so that the political pressure that visibility creates can eventually be directed not at individual cases, but at the system that generates them. Where does this go from here? The most immediate signal to watch is the Yahaya Sharif Aminu retrial. The case was remitted to the Kano Sharia Court for retrial with proper procedural compliance. If the retrial proceeds under the same legal framework with proper procedure this time, it produces the same sentence, death, without the procedural error that provided the previous escape valve. Watch for whether any federal institution responds to that outcome differently than it responded to the original sentence. Watch for the next blasphemy case. The community reporting infrastructure that produced the Yahaya Sharif Aminu case is still operational. The social media monitoring, formal and informal, is still active. The legal framework that makes the report actionable is still in force. The next case is a matter of when, not if. Watch for whether it proceeds in the same federal silence or whether the accumulated visibility of documented cases has created enough political pressure to produce a different institutional response. Watch for any movement on Section 39 litigation. Any human rights organization, any individual defendant, any diaspora-funded legal strategy that attempts to bring a direct freedom of expression challenge to the blasphemy provisions in the Supreme Court, that case, if it is filed, is the most consequential legal development possible in this space. The 5-year trajectory if nothing changes. Yahaya Sharif Aminu's retrial proceeds. The next blasphemy case proceeds. The next apostasy case operates through informal enforcement without formal prosecution. The pattern continues. The federal silence continues. The procedural escape valves continue managing international pressure case by case. The constitutional architecture continues standing. The 5-year trajectory if visibility produces pressure. The accumulated weight of documented cases, Safia Hussaini, Amina Lawal, Baria Magazu, Yahaya Sharif Aminu, Omar Farouk, Mubarak Bala, becomes the evidential foundation of a constitutional challenge that a Nigerian or international legal institution is willing to file and fund. That challenge forces the Supreme Court question. The question forces the federal government's reckoning. That response forces the constitutional reckoning that 25 years of silence have made increasingly explosive. Here is what nobody is saying. How does a country with a written constitution arrive at a place where a 22-year-old is sentenced to death for a WhatsApp message? Not through judicial failure, not through legislative accident, not through the actions of rogue officials operating outside the system, through design. Through 25 years of deliberate federal silence that allowed 12 state governments to build a parallel criminal justice system whose provisions are irreconcilable with the constitutional rights of the citizens it governs. Through a political class, both northern and southern, that found the silence more convenient than the confrontation. Through a Supreme Court that has chosen, case by case and year by year, procedural avoidance over constitutional clarity. Through a foreign funding infrastructure that built the ideological ecosystem in which these provisions feel not just legitimate but mandatory. In which a community can report a WhatsApp message, watch a mob burn a family's house, and understand both acts as expressions of religious duty rather than as the persecution of a citizen whose constitutional rights have been violated. Yahya Sharif Aminu shared his song. He is on death row. His family has no house. The federal government said nothing. That is not a failure of the Nigerian state. It is a choice of the Nigerian state. And choices have authors. 25 years of documented authors who have never been asked to answer for what they chose. Here is my question for the comments. Yahya Sharif Aminu, Omar Farouk, Mubarak Bala. 3 young men, 3 cases, all in 2020, all in Kano, all in a country that has a written constitution that should have protected every one of them. If you had to name the single institution, the presidency, the National Assembly, the Supreme Court, the Kano State Government, or the Nigerian Bar Association, which one, whose action or inaction most directly enabled these sentences would it be? One institution. Drop it below. If this analysis gave you clarity, share it with one person who needs to understand what is really happening in Nigeria. Like, subscribe, and I will see you in the next one.